What will you do when someone copies your trademark? Say your trademark is Bisleri and someone copies a deceptively similar name to that. Say Belseri, Bilseri, Brisley, and so on and so forth. How to handle such situation efficiently? Let's talk about that in this video. Hello, my name is Advocate Rohit Pradhan. I'm a Delhi-based lawyer primarily practicing before Honorable Delhi High Court and district courts across Delhi and Delhi NCR. So let's come back to the video and let's make this video in question and answer format. The first question that pops up is that should I be sending a legal notice to the infringer? While it does make sense to send a legal notice to the infringer, because say if you send a legal notice, you will think that what if they get scared and they will think that okay, you are onto them and they will stop infringing your trademark rights. The next question that comes is that why to sue them when you can just send them the legal notice? I mean, like, I'll save a lot of money which I could spend in litigation. Rather, I could just send a legal notice and what if they will stop? I think that's a very great bet. And you know what? I might even send a legal notice without my lawyer's approval. What could go wrong? The answer is that yes, you are half right and half wrong. While it could be economical to send a legal notice without your even lawyer's approval, just send it. But there are repercussions. There are two major setbacks to that. The first major setback is that do you even have the legal right to send a legal notice? Because when you send a legal notice, you put a ground that you have been infringed, there is a case of passing off, and if they do not stop, you will sue them. Basically a threat. But for some reason, say that you send them the legal notice and somehow you do not have the legal right to do so, something that you even didn't know, and you send them a legal notice threatening that they stop infringing your trademark or else you will sue them. Well, under section 142 of the Trademark Act, if that turns out to be a groundless threat, the person to whom you send the legal notice will have the legal right to sue you, and not only sue you but also claim damages and compensation. So you will have to think twice before sending a legal notice. You may also read the case of Ahilya Vedanta versus Ahilya Education. The second setback is if at all the infringer has this malicious intention that that they have been infringing your right doing passing off, just after getting a legal notice they might just hide whole of their machinery, whatever they need to create a second copy or infringing your trademark rights. They can just hide all of them. They may just shift their whole operation in some other place that you might never know of, and then there could be no way for you to go and catch them red-handed. Now the third question that pops up is that then why to even sue them? Because if by sending legal notice they can hide all of their operation, they can do the same when you sue them, right? And the answer is that no, it's not right. They won't even get a chance to hide anything. It will be a surprise visit. Let me explain. So it's a rule that when you sue someone, you have to give advance notice to that other person that hey, you have been sued and the next date of hearing is this and this date and you will have to appear before the court. But in the case of trademark infringement, when you sue someone and you put an application for the appointment of local commissioner, then this rule of sending an advance notice can be get exempted. In such situation, you do not even need to let them know that the case has been filed against that person. You will have to explain before the learned judge that there is a case of passing off and infringement. The learned court appoint a local commissioner and also direct the local police authority that they assist the local commissioner, and all of them go to the premises of the defendant and raid that place, and even if required, break the locks. And this way defendant would never even know what happened and they wouldn't even get a chance to hide anything. Now the LC and the police officer will raid that place, and after raiding that place they will collect the evidences. Now you might think that okay, they might raid the place, but if they would do it efficiently, and according to the court order, a representative from the plaintiff also accompany the police and the local commissioner to raid that place, and he makes sure that everything goes efficiently because it's the matter of its client. Now you have raided that place, you got your evidences. Now you go before the learned judge, show them the evidences, and the proceeding goes on, and the other side is injuncted to ever use your trademark or any mark which is even deceptively or closer to your mark. Not only that, you can also claim the cost that you incurred by engaging lawyer, the local commissioner, and all the legal processes. There are ample of cases where the plaintiff has been compensated for the cost that they have incurred to initiate the legal proceeding. So effectively, there is not much of an expense when the things are done correctly. The fourth question comes is that how long would it take to conclude my case? And Honestly, there is no concrete answer to that, and let me explain why. There are a lot of things that goes on when the court case proceed. However, if you want to take a very rough answer, give and take, there has been many instances, say in Delhi High Court, you get the interim relief in day 1 or day 2. And once you get the interim relief, then the case goes on for months and years, and then finally the case is concluded. And when I say that you get the interim relief, I mean that in day 1 and day 2, the defendant is injuncted to use the mark till the case is closed. So there is no prejudice against you when you file the case. You know that if your case is genuine, the other side will be stopped in day 1 or day 2. And if the other side still continues, he will be charged under contempt of court. However, this trend of getting interim relief in day 1 and day 2 might change. As recently in the case of Dabur, Imami filed a case against Dabur for the use of the brand name Dabur Cool King Thanda Tel. According to the Imami, its trade dress and trade name was similar to their trade dress and trade name. It took them 2 hearings, and in 2 hearings, the learned single judge injuncted the Dabur to use that trade name and trade dress. Consequently, Dabur filed an appeal at the division bench of the High Court. The learned division bench was of the opinion that when a brand is in the market, then the brand should be given an opportunity to at least put his or her case, and then only an order for injunction should be given. So as a result of it, what could happen is that you might not be able to get interim relief in day 1 or day 2 as you used to get before, but could take around weeks or months to get interim relief. However, in exceptional circumstances, as held by learned judge C. Harishankar, is that in exceptional circumstances, you might get interim relief in day 1 or day 2. Also, we have Supreme Court rulings which states that in case of trademark infringement, the case need to be heard expeditiously. So it is not like those regular cases which take decades, 5 years, 6 years. Most of the cases gets concluded within a period of a year or 2. Or the interim relief, as a matter of fact, you might get in a period of a month or 2. And in exceptional circumstances, you might even get the interim relief in a matter of period of day 1 or day 2. The fifth question that comes up is that, okay, Delhi High Court sounds great, but I do not live in Delhi, I live in Mumbai, and my product is being infringed by someone who is also not from Delhi, say he's from Madhya Pradesh. So can I sue that person in Delhi High Court, considering that Delhi High Court has such a fast track record to adjudicate upon these kinds of matter? So the answer is yes. Basically, it depends. If you have a brand name and the infringer is actually have copied your brand name and is selling some product with that brand name online, and a person sitting in Delhi could buy that product, then effectively you can sue that person, the infringer, in Delhi, because it is somehow affecting people of Delhi. So automatically the jurisdiction will come to the courts of Delhi. I hope you liked this video. In case you did, hit the like button, and in future if you would want to see more such content, then hit the subscribe button. Thank you so much.